trek today, and those that are coming from far and wide. This is, oh gosh, I'm going to say this has got to be 5th or 6th annual risk management meeting, and over the years we've kind of covered a lot of different topics, and I think today you're going to see some familiar faces and you're going to see some new faces. So in that, I just want to make sure you're aware that we are trying to respond to input, and in the past we've gotten some feedback about the topics. We want more of this, or we want to see some other things as well. So one of the little housekeeping things I want to just mention here is we're going to have 2 speakers up front, and then we're going to take a little break and get resettled, and then we'll finish with the last portion of the meeting, but very informal. So the restrooms, there's two spots. You can go around the back side here. There's a set of bathrooms, or you just go down the hall, right out that door, and when you get to the point where you can take a right, just right around the corner is another set of restrooms. Very informal, as I said. We want this to be as interactive as you want to make it. This is information that applies to everyone in the room at some point, and so we want it to be informal, so feel very comfortable. I got to admit that I stole this slide from someone that I recently attended one of their meetings, but he didn't say it, so I can steal it without any copyright issues. But I thought very appropriate when I saw that, that we deal with this 12 months out of the year. Every morning we get out of bed, we're taking some risks. And it's not about the fact that we can totally eliminate risks, but it's about mitigating them and having them in our sight so we know what we're dealing with. So as I said, today the information is not going to be about the speculation, but again, this meeting is for you. It's to you, and it's about you. So and also I want to emphasize why is AgQuest and UFC together and putting this on? It's a partnership that's been going on for many, many years. So AgQuest is a lending and insurance institution that's partially owned by United Farmers Co-op. And through that collaborative relationship, we've also expanded and developed some partnerships and some relationships with ART and Kansas State. And also our first speaker here, we'll introduce here in a second. But so with that, don't hesitate during the presentations. We certainly welcome questions and comments or any reflections. So our first speaker this morning, Lee Hanson, comes to us from Gray, Plant, and Moody. It's an attorney firm out of St. Cloud. And Lee in particular can relate very, very well to all of you in the room. Born and raised on a farm in western Minnesota, has siblings that are still on the farm. He himself has actively been engaged in some farming capacities through the years, and today obviously works with some tenants, as he mentioned, that rent a few of the acres that he has around his house. He's also a collector of tractors, so he might elaborate on some of those things, and might even pertain to some of those little details about estate planning and trust and so forth. But part of what Lee and the rest of us are speaking to specifically with this topic is, a lot of you, especially those my age and older, are part of the baby boomers, and we're coming out of what some people are saying is potentially one of the golden ages of agriculture. And yet at the same time, there's those inevitables that are coming along. We've talked about uncertainties in life, our death and taxes. And Lee is going to talk about some of those things that pertain to those two topics. And yet we can't avoid them. It's coming. So this might be the first time, second, third, fourth time we've heard some conversation about this. But we truly believe in the cumulative effect. And I think you'll agree as you listen to Lee, if you've heard some of this before, it's very pertinent and so forth. So with that, I'm going to turn it over to Lee.
Well, as Vince said, I have been involved in ag my entire life. My brothers are cow-calf operators and irrigators at Bruton. I live on a farm up by Rice. where it's pure sugar sand. And one little quick story I want to tell you before I get started. It turns white along the Mississippi River when it's dry. And my dad, of course, is an old Norwegian farmer, and he comes out there and he digs his toe in the dirt like this. And this is 1971, and he looks at me, and I paid $14,000 for this whole farm, 120 acres with a house on it. Not a very nice house, but we moved into it. And he says, "Lee, you sure got taken when you bought this farm, didn't you?" And I said, "Well, Dad, I only paid half as much for the whole farm as I would have paid for a house in town. And I'm going to be working in town, and I'm just going to live out here, so I don't have to make my living on the farm." But that did not, as you would expect from him, cut any ice at all with him. But today it is worth something, and even though I didn't realize it at the time, it was one of the best investments I ever made. But before we get into the nuts and bolts of this, one of the phenomena that is going on, and you are all part of it, I'm part of it, is if you go from St. Cloud west to the Minnesota border, the average age of the farmers is 75. Think about that. Not many people do think about that. We are losing our ownership and our operators in our rural lands. I just met with a bank examiner out of the Des Moines office who was up in Minnesota because there was no work in Iowa because there's no loans down there and there's no defaults. 70% of Iowa farmland is unencumbered. 60 to 70% of Iowa farmland is owned by widows and is operated by rental tenants. So we are losing our entire way of life in our rural areas because of the large farms and so many of the second, third, fourth, fifth generations not coming back to farm anymore. And of course, I'm one of them. I've maintained some connection, but that's one of the reasons, one of the human reasons that I want all of you to think about a way of keeping your farm in your family or in a family that's going to own the land that they're going to operate, not just be a tenant of that. Because when that happens, your local communities eventually go away. There's no leaders left in the community to be on the school board, to be county commissioners, to do any of the grassroots government that we all took for granted when we were growing up. Okay, when I start an initial meeting with somebody, and this is kind of what I would go through, and this is an example, but it's not perfect, and it's not going to fit everyone. I've set this out as two 50-50 partners. Many of you are going to be father-son operations, but I've got slides that cover this, and some of this will cover some of your issues, but not all of them. But the best way to start, of course, is obvious. We want to know the history of the business, the current size and the value, and what do the owners want to have happen. Now, you don't have to take any notes. Every one of these slides is on a handout, but I'm not going to give you the handout till we're done, because I want you to listen to me and not be paging through that handout. So here's the fact pattern that I picked out. Two 50-50 owners, been in business for 20 years. I should have had land down here, not Holstein cows, but I didn't change the picture. Got a number of employees, both spouses help in the business, and they own the business real estate, which would be the farmland personally. Typical farm operation, it fluctuates. Past few years have been good. I did this 2 years ago before the price of corn went down. And really don't know the value. Neither of the spouses is going to be active in the business if something happens to us. in this case, have children, but no children with an interest in the business, because I'm trying to work out a sale example. So the two partners have agreed that if anything happens to either one of them, they want to take care of the other one. And that can be partners, it can be a father and a son, it could be a father and a long-term tenant. But the point of it is that an oral agreement will not work. An oral agreement is not going to stand up. A handshake is not going to stand up. Most people have never had it even communicated to independent third parties. And it does not constitute any kind of valid succession plan. And so then the issue becomes, where do we start? And the place that we all have to start is with the value of the business. And a lot of times people will say that they don't have a good idea of the value. We all know, though, that everybody has a good idea, and it depends on whether you're buying or selling. If you're buying, you want your value as low as possible. If you're selling, you want it as high as possible. So it's just a negotiating kind of match. And one of the issues that I have to deal with a lot is where the negotiating cost, the negotiating strength is unequal. One person might have a lot of strength and the other one might not have any strength, have no value and no ability, no credit, no ability to borrow money, so they don't get a fair deal. So one of the points that I always make is it's important that all of your other stakeholders, your lenders, your investors, your any other business partners and suppliers know that you've got a succession plan. I also do a lot of work for construction companies, and a lender wants to know if you're over 60 years old and you're going in for an input loan, they want to know what's going to happen if you have a heart attack or a stroke. I'm just in the middle of a big development project in Cold Spring right now. The lead brother, three brothers, the lead brother had a heart attack, 57 years old, and the banks called a meeting the next day and said, we're not going forward with this project till we know that that person is recovered. Just stop a major project right dead in its tracks. So we've got to, everybody's got to know that there is a plan and what the plan's going to be and who's going to take over if the lead person is killed in a car accident or incapacitated with a certain health event. I just got another case with an asphalt paving company where one of the two brothers that owns it, 51-year-old, just before Christmas was diagnosed with pancreatic cancer. And as most of you know, that is almost always a death sentence. So my other point there is, if you have a strategic or a succession plan, it can be part of your strategic plan. What do we do and how do we operate our ag business if one of the partners is gone? Do we have to bring in somebody else? Do we have to cut back? And what will our lenders say? So here I just put this on as an additional slide, that's why it's a different color, just to lay out for you the different kinds of business entities. And most of you are familiar with these. You can either be operating as a regular corp, which accountants and lawyers call a C corp, or an S corp, which is simply a pass-through entity for tax purposes. Limited liability companies are a hybrid between a corporation and a partnership. They have the limited liability aspects of a corporation, but they have the pass-through entities for tax purposes as a partnership. Then itemize something that is the major problem in moving assets from a father to a son. And that's, I just call that a straight up sale. And let's take equipment. And most of you know this, most of you have accountants that will tell you this. Do not ever enter into any kind of transition plan or business succession plan with your lawyer without involving your accountant. Because all too often, many lawyers do not understand the tax accounting rules. And I've just given you an example on the board here. All of your equipment, all of your machinery, tractors, rolling stock of any kind is classified as Section 1245 property for tax purposes, which all you care about is that you can depreciate it very fast, like 5-7 years. And with the Section 179 at $500,000, you can write off $500,000 worth of purchases in any 1 year. Well, here's what happens when you sell any of that. I just put an example on. Let's suppose this is machinery you've had for 5 years. You've depreciated it all to zero. And you're going to sell it to your son on an installment method because your son doesn't have any money of his own. And he's going to pay you $10,000 a year plus interest. Let's assume that the son pays $10,000 down on that group of pieces of machinery. That's not going to get you very much today. But even though the down payment is only $10,000, you recapture all of the depreciation you've taken on that equipment in the year of sale. Even if the down payment had been zero, you would have $100,000 of ordinary income that year because you sold it. And all too often in my early days when I was doing this, a father would sell to his son on a napkin or something, and they do this in the middle of the year, and then they come in to get their income taxes done, and their accountant would say, well, you should have talked to me before you did this because you're going to have a huge tax. Yes?
If you did the exact same thing when they wrote up a piece of paper that was a lease.
You just stole my next point. No, perfect. That's the way you do it. So what you do, you've got to avoid this. You structure the payments exactly the same way, but you write it up as a lease. And there's a few things you have to be careful for in a lease. You can't, at the end of the lease, say, let's just make it a 10-year deal to make it real simple. Say, we're going to make these payments over 10 years, and at the end of the 10 years, it belongs to my son. That's what's called a capitalized lease. The IRS says, well, that's just a sale. And so what you've got to say in your lease, at the end of 10 years, my son is going to buy this equipment for its then fair market value. It's going to pay the fair market value. Now, those are the magic words. And so what I do is I usually run a 9-year lease, and then I have that language in my lease, and I say after 9 years, the son can buy this equipment for its then fair market value, and I have a separate document that's not part of the lease, and I say the parties agree that the fair market value of this equipment at the end of the 9th year is going to be $10,000, 1/10. So it's the last year's payment, really. You've got to say that, and you've got to follow through on that, because the IRS watches for this, because otherwise they'll advance all of that to the first year. But yeah, that's the way you solve that problem, is make it a true lease. And a true lease is one that in its body says that the tenant or the lessee is going to pay the fair market value of this equipment at the end of the lease. Good point. Any other questions on that? Because this is the stickiest part of a transfer, a sale transfer from a father to a son.
Is there ever any question as to what the fair market value at the end is? Because of the rules, you just put down the last payment is.
Well, you can't say it quite that simple, because then they'll argue with you. You've gotta make it look like you have agreed that you've done some study and that the real true fair market value is whatever the number is that you're putting down. So, one other way to do this, this is what my brothers did with my dad. I set up both cattle and machinery on a lease basis. We were cow-calf operators and just leased it. And then, you know, you don't keep the same machinery all the time, so what my brothers would do is just trade in this equipment from time to time on new pieces. They would take whatever they paid to boot, and they'd put that on their depreciation schedules, and they would just keep paying my dad the same amount that they've been paying him, but he allowed them to trade that equipment in, so at the end of 10 years, a lot of that equipment would be gone, and we just said that whether the equipment was there or not, he kept making the same lease payment, and gave my dad a second security interest behind the bank in whatever equipment that my brothers bought. So you don't need to keep the equipment, you just need to keep making the payment.
Do you need to structure this for, instead of just saying machine, can you just say machinery, or do you have to list individual pieces?
No, you can, well, you can, yes, you should list the pieces so that if somebody dies, the son knows what he's getting. I mean, it's, or you can, unless it's all the machinery, just say all machinery and equipment located and previously owned and operated by my dad or Mr. X.
But if you do that, then when you sell a piece, how can you sell a piece of leased machinery?
Well, you trade it in. That's my point. You trade it in, so it never shows up. The son gets a benefit on the trade-in, you know. So that never shows up on his tax return. All it does is he's just getting equity in it because he's paying the lease payment.
So the son would get the
benefit. He'd get the benefit of the lower.
And the father would just disappear.
Well, the father doesn't disappear. The father continues to get his lease payments.
Right. I'm just saying but when the father bought that piece of equipment,
yeah,
I mean, it was on his balance sheet.
Yeah.
But then when it's traded in, it just disappears from his balance sheet.
Yeah.
The new piece goes on the son's balance sheet.
Well, what I've done in the past, because the dad is still getting his payments, when I've traded it in, I've just had usually it's all depreciated out on the dad's balance sheet, so nothing happens there. And being it's a trade, under the rules of the Internal Revenue Service, it's a like-kind exchange, so there is no tax on that trade. That's under section 1031 of the code. Just like trading real estate, you can do the same thing with machinery. That's why you never pay tax on the equipment you trade in when you buy another piece of equipment. So you might have a $100,000 combine, trade it for a $300,000 combine, and that $100,000 is depreciated to zero, but then you only pay $200,000 to boot. Your basis in the new combine is $200,000 and no gain recognized on the old one. So basically you lost basis in the new combine by trading in the old one. Any other questions on that point? This is something that is just another reason I tell people get these things in writing and get them signed so they're valid and enforceable against third parties. So I just point this out because these are open issues. You've all had this happen to friends of yours at one time or another. What happens if there's a divorce, a disability, retirement, or death? Who's the buyer going to be? And how much are they going to pay? What is the relative negotiating position? Are you going to get a fair value? What assets are included? And what will the value be? What will the down payment be if it's to a family member? And if there's a loan, what time period and what interest rate? And what are the security provisions? Kind of those last four. When I do something between a father and a son, I like to break conceptually the whole arrangement into two pieces, one for the equipment and another for the land. And if I've got enough time, I want to do the machinery, and if there's livestock, that piece goes first. And I want the son to have got that pretty well paid off before they bite into the land. And that way, if something goes wrong, because today there's a lot of issues. I've got more problems with spouses of sons and daughters that are taking over land than anything else. And they don't like that way of life and they want to get out of it. So I want to know that their feet are in the cement before I put the father's land at risk. And so what I do though, and that's the last 4 points there, if I've got a purchase agreement on the machinery, and then I have a separate lease so that the son has got a lease for the land, and he knows what he's paying for rent, but more importantly, I put into the lease, in case the dad has a heart attack or a stroke, and let's say there's 3, 4 other kids, I put a purchase price for the land so the son knows I'm not going to buy all this equipment and then not have any land to run it on. So that if the son pays off the first chunk and has the machinery paid for, he has an option to buy the land at a fixed price. And I always give the son at least 5 to 7 years on a contract for deed, so that he doesn't have to go out immediately and refinance the land with a third party in case rates are up or down or the ag economy is tight like it is right now. And so my favorite technique is maybe a 20-year amortization schedule, a 5-year balloon, and a favorable rate, 3 or 4% interest rate. But that way, if the dad has a heart attack and all the other kids come home and say, let's sell the land, the son can say, no, I've got a deal, and here it is. And I was talking to one of you before this started, I sit down with the entire family when I do this and say, this is what your mom and dad have decided, this is why they've decided it, you talk to your mom and dad right now. Don't wait till they're dead and then get mad at your other brother that got the farm. And so I want to make sure that everybody understands this is the parents' plan and the way the dad wanted it done. And if they are unwilling to communicate it to the other kids, I communicate it in their presence so that we get to the bottom of it at that point in time. And that's where those 4 points are. That way, you don't have to, if you're the farming kid, you don't have to sit down with all your brothers and sisters and try to work out a deal after your dad's just died of a heart attack. And I've got some real life cases on that. In my case, it was almost the opposite. My mom and dad have been married for 51 years. My mother dies. My dad's 9 years older, and he gets married the next year, and he's 76 years old. But he at least came to me and said, well, Lee, let's get this land squared away before we get married. So I entered into a contract for deeds with all my brothers, between my brothers and my dad, because my dad had bought a lot of land around Bruton. And so we had contracts, and my dad didn't give my brothers. One of my brothers went and bought some land from somebody else and got a better deal than he even did from my dad. So he did not give, he gave terms and he gave good interest rates, but he kept the price up pretty high, I thought. So I've had all this happen, and I had another case in my wife's family where she was from Starbuck and a farm family, and I did a contract for deed for her brother, and it was 3 kids, and about half price, about half of what the land is worth. And we all sat around the kitchen table and agreed on it, and then her brother gradually paid it off over a 15-year period, and then few years after that, her dad dies. And my wife's sister calls me up and says, Lee, we've got to change that price that Harvey paid for the land. He didn't pay enough money. And I said, Gloria, I said, that deal's done. He's paid for it already. I can't do anything about it. I said, you were right there at the kitchen table when we did this. If you didn't like it, you should have said something then. Well, Lee, that's not right. You've got to do something about this. And I said, Gloria, I'm not going to, and I can't. And if you would have ever told me that this woman would say this, I would have said, you're crazy. She is the most meek, mild-mannered person, but she had never had anything to do with business or anything. And it just goes to show you, you can't tell what people are going to do when money is involved in inheritance. So she went to a lawyer in Starbucks, called him up, and told him about this, and I knew him. And so he calls me and he says, Lee, what's the deal with Gloria? I said, Chuck, don't pay any attention to her. She's just plain crazy. But here's the human tragedy of that. She didn't talk to her brother Harvey for 10 years after that. Now, my wife finally got him back to rehabilitate the relationship, but I don't know in that case how you would have changed things, because she knew what had gone down. And she knew everything about it, and she did it, and the other part of it is her own husband is from another farm family in Albany, and they did this. He didn't get anything out of that farm, nothing, because their dad just turned it over to the brothers. And I finally said to her, I said, Gloria, how much did your husband get when your dad turned his dad turned his farm over to the other boys? So these are just difficult situations, but the more open you can be at the time you're doing it, and the fairer you can be, you should not be disinheriting the other children just because one of the sons has stayed home, or son-in-laws. I've got some son-in-laws that are doing this too. But, I know that how even I think a dad always wants to keep the price down to the point where he knows that farm son can make it. But there are a lot of other things to be thinking about other than that. And today, people are living so long that a lot of sons are just waiting for their dad to die so they can retire themselves. And then they either sell the farm or get the rent. Yes?
When you talk about the tragedies, I feel compelled to repeat what I heard at a meeting in Des Moines a couple of summers ago. We were sitting at the lunch table, and this one guy, he was retired, and he was telling his story, and he had 540 acres paid. He had his son was operating with his family. He had 2 daughters, not farming, in-laws. And that was when the booming in big houses was. And the in-law boys, they thought, hey, why are we, and he had deeded it, kind of, he went through the process, but why are we messing with this? Why don't we just sell our share and build ourselves a $700,000 house and have it paid for? Well, then the 2 brothers-in-law got together and ganged up. And his final words were, we can't, and he did say that they had, when in younger days, he got along blessedly with his children. He says, we have 3 Christmas dinners, we have 3 Thanksgiving dinners, we have 3 Easter dinners. We can't get all 3 families in the same room. His final words were, if I do it again, in his words, I'd give the whole goddamn thing to the church, let them all be broke.
And there you are. No, and I live with that every day. Okay, let's keep moving.
Got a question.
Yes.
If you have, say, a will set up or something like that.
Yep.
Do you have to have a dollar value on the land if you want to sell it? Or
No.
say a fair market value, and how do you determine that?
Well, no, let's take that two questions. That's a good question. You do not have to, you can give anything away, and I've got a whole slide on that, but as long as you ask, let's cover part of that right now. In the United States, every United States citizen has an exemption of $5,430,000. That's your unified credit this year. It's indexed to inflation, that's why it's an odd amount. But you can give that amount away today if you want to, and if you're married, you can double that, so a married couple can give away roughly $11 million anytime they want to. That's separate and apart from the annual exemption, gift tax exemption, which is $14,000 per person per year. So to answer your question directly, you can give anything up to $11 million away if you're married. Don't worry about it. There's a separate issue, though, included in that question that you're not maybe thinking about. Even though you give something away for nothing, your family has to pay federal estate taxes and state estate taxes on the true value, whether they get any money or not, to the government. Now, if it's under 11 million, federal level, nobody cares. If the state exemption in Minnesota, and I've got these slides on the board, so you'll get those when you leave. The state exemption this year is $1,600,000 per person. So you and your wife each have 1.6. That's going up to 2 million by 2018. And this is a little bit complicated. The other thing you should hear, and this is in my slide, the federal tax rate is a flat 40%, high exemption of 11 million or 5.5. But once you get over that, you give 40% to Uncle Sam. So if you got a $20 million estate, you're going to give Uncle Sam $4 million. And in Minnesota, the tax rate is 12%, roughly, and I'm averaging it, but it's between 10 and 13. So anything that you own, if you're single in Minnesota now, over 1.6, you give 12% to the state of Minnesota. And these taxes are all due 9 months after death. Now, there's a 100% marital exemption between spouses. So all taxes are delayed till the second death if you're married and your spouse gets the assets. So that's a little bit of a complicated answer, but I've got a slide right on that. So don't worry about remembering it. It's all pretty well laid out. But that's the one point that I work on all the time in Minnesota, because Minnesota does not have a gift tax, but it has an estate tax. So to the extent we give property away in Minnesota, we avoid the Minnesota estate tax. There's a big consulting firm now doing a study of the financial drain in Minnesota because of our high income taxes and our high estate taxes. Every person that has mobile wealth moves out of Minnesota when they retire because of the income tax, highest in the nation other than California and New York, and the estate tax is the highest in the nation. Oh, these are just points for having a written agreement so you know who's going to take over. There's another piece on here today that as your ag operations become larger and you have more outside employees, that's really critical. Employees, especially high-functioning, loyal employees that don't know about a succession plan, if you have a heart attack or a stroke or any kind of health event or die, they are the first ones to get raided by your competitors because they don't know what's going to happen. So make sure that if you have a large operation and high-functioning employees, good employees, they know what your plan is, that they've got a job and that whoever's taking over is going to be taking care of them and wants them to continue working. That statistic, I've seen now since I put this together, were cases where people have got a lot of debt, and if we don't have a smooth succession plan, we lose all of the value simply because we can't carry the debt. And that's one of the issues that I'm honestly worried about in the ag area today is people that, and there may be some of you in this room, bought high-priced land, and if you can average it across a lot of other acres that are either unencumbered or low debt, you can carry it. But right now, there isn't going to be, for these next 2 years, much operating income to pay debt other than your own input costs. I'm going to just give you this. I think most of you are aware of all those points, but it's just a way to remind you how important it is to have a written plan. This is a slide that I'm using more and more. It's an alternative method of buying into a business with an employee that doesn't have any money or a son that doesn't have any money. And I have used it in a lot of different businesses, and it's set up really as retirement income out of a business. And it works really well in any kind of business. And the key part of this is this, write this section down for you go, if you want to think about this, this is 409A of the Internal Revenue Code. Basically what that section says is that if you have put all your equity into a business over the years to grow the business, so you have additional working capital, the Internal Revenue Service allows you to draft an agreement that says, when I retire, I'm going to take X number of dollars a year out of this because that's money I left in that I could have taken out during the years I was working. And so the point of that is that all that money comes out as ordinary income to the father, if it's a father-son, and the son can deduct all the payments as business expense. So, you know, otherwise when you're buying land or you're buying machinery, all you can do is, well, machinery is pretty good because you can depreciate it fast, but other assets that are not depreciable, or if you're buying corporate stock or partnership interests, you can't write that off. But if you structure this as a retirement income, you in effect convert a lot of the sales price and the purchase price to deductible payments. And you only pay Social Security on the first 1 year's wage base. So let's suppose it's a large operation. I'm going to pay my dad $2 million over a 15-year period. And well, let's just say $2 million over a 20-year period. Make it easier so I can do the arithmetic in my head. $100,000 a year. So, and that's going to be a large part of what he gets. Now, that entire $2 million is going to be deductible as it's paid, $100,000 a year, just like a wage. But the dad doesn't pay Social Security on anything after the first $116,000 or 17, and the son doesn't pay his FICA share either after the first $116,000. So it's a beautiful way of getting pure retirement income and getting a credit for it, because what you do is you book that payment as a liability, as an account payable on the books of the organization, so that it draws the net equity down, so then you don't have a gift tax problem at all, and you recognize that as part of the liability of the organization, so that you can sell the non-depreciable, the non-write-off part of that at a much lower price. And what I've done this for every other different kind of business. And what I do, because that in some cases will be the biggest liability on the books, and because it might even cause your organization to have a negative value for book purposes. And so I always go over this with the banks, and when I do it for construction companies, they've got bonding companies, both the payment and performance bonds that they have to provide. I say right in the 409A agreement, this is subordinate to my institutional financing and my bonding, or whoever else, and in your case would be input liens, so that the banks don't get scared, so that the banks come ahead of this. They can count it as equity, but between the father and the son, it's debt, and it's valid debt for Internal Revenue Service purposes. So, this is just kind of a diagram to help people understand it. It just, what it does is it draws the purchase price of any organization down, because I'm putting a big liability. All I'm doing is putting a liability on the books for the, you might even call it retirement income or consulting income. I'm going to pay the dad over the maybe the remainder of his life. Now, if the dad dies during that period, those payments continue. They're fixed. They continue to a spouse. And if both the mother and dad die, or there is no mother, then the payments go to the trust or the estate of the dad. So that's a way the other kids are going to get their money one way or another. Yes.
If they go to the estate, so the estate can't be closed until that payment is done?
No, that's another good question. That's a very good question. The question was, do we have to keep the trust or the estate open for that entire period? The answer is no. You can parcel that out so the payment goes and close the trust or the estate, so that, let's say there's 2 other kids. You just divide it between the other 2 kids, and they parcel out that contract. And if there's 3 kids, to 3 of them. And the more kids you have, of course, the tougher it gets, but you can still do it.
But if there's 2 kids, so then the income that the 409A pays to them is still non-tax?
Yep.
No social security tax on that?
Right. Oh yeah, exactly. Yep.
Okay.
But the best way for you to deal with that is to talk with your accountant. I always bring an accountant in when I'm doing that. So what I'd like to do now, I'm going to switch topics a little bit, and I'm going to go over, there's a couple more slides on this one that I'll take. But if there's any questions on kind of this family business transition planning, let's start covering those questions.
Is 409A, is that relatively new?
No, it's been in the code forever. It just hasn't been used much. A lot of accountants just are not familiar with it. They just issued some final regulations on it about 5 years ago, and what it's used for a lot is in these big public companies where people get big severance contracts when they're fired, and we just use it for a different purpose. I'm going to go through just a couple of points on estate planning, but I don't want to jump into this until you've had an opportunity to fire off any questions you might have on just transferring businesses down to a son. One other point that I do want to make about transfers, especially with this high value land right now, anytime you gift land or any asset to somebody, and to a son, let's say, that son takes that asset with your cost basis. So if it's a tractor that you paid $150,000 for and you've depreciated it out, they have 0 basis in it and they cannot start depreciating it again. If it's land that you paid $1,000 an acre for and it's worth $7,000 today, they take it with a $1,000 basis in it. And so when they go to sell it again, if it's been gifted, they have a huge tax on it. That's what's called carryover basis. If you die owning that same tractor and that piece of land, your son, and it goes to your son, they get a stepped up basis. So that's the benefit of keeping assets till your death, if your son is going to sell them or wants to depreciate it. That tractor that you paid $150,000 for, let's say it's worth $100 today, your son gets a new $100,000 basis, and can start depreciating it again all over. And the land, what you can't depreciate, but if it's worth 7 when he inherits it, he can sell it the next day for $7,000 an acre and pay 0 income tax. That's what lawyers call keeping your high value, low basis assets in your estate and die with them, and gifting away your assets that have a value equal to their basis, like cash.
Almost as good as the Powerball.
Yes.
Does that work, even if you have let's say you had a 20-year contract for deed, you're on year 19, the person dies or everybody dies, and so then you still get it as stepped up basis?
No, a contract is a completed sale as of the date you signed the contract. You're stuck with that basis. Yeah. Good question, though. Very good. We've all tried to figure out ways around that. Okay. And because of this high tax, those of you that have life insurance, and especially large policies, you should get that life insurance out of your name, because otherwise, if you've got more than $11 million estate, half your life insurance goes to Uncle Sam when you die. So put that in a separate trust that you don't have any control over, or in an LLC that is completely owned by your kids. When I have any large life insurance policies today, I get them out of the insured's name. Otherwise, you're just giving Uncle Sam half of it. And so these are the benefits of a trust and estate planning. I've got some better slides coming up here. Here's the slide I just was talking to you about earlier. Federal estate tax. It's the same for 2016. The first $5 million is exempt, 40% tax on everything over that, 100% marital exemption to a surviving spouse. The federal gift tax is exactly the same as the estate tax. It's called the unified tax. The Minnesota estate tax, I did this in 2015. It isn't updated yet, so that 1.4 million exemption should now be 1.6, and the rate, I just use at 12%. The Minnesota gift tax has been repealed. One other thing that is in my slides that I will talk about a little bit later. Let's say that a couple has an $11 million net worth. And the husband says, and they live in Minnesota, the husband says, everything I have, I give to my spouse. And so she gets, and whether it's all in his name or half in his name, everything that spouse gets, she gets under the 100% marital exemption. So the husband at his death did not use any of his $5 million. So now there's a new concept in the federal law called portability. So the wife, when she dies, actually has her own exemption of $5,430,000 plus her husband's exemption of $5,430,000, and so the wife has an $11 million roughly federal exemption. The catch with that is we do not have portability at the state level. The state of Minnesota, you use it or lose it. So in Minnesota, you would never give everything to the wife. You would keep today, if you had an $11 million estate or even a $4 million estate, you would keep $1.6 million in a separate trust that never went to the wife, so you didn't double up and lose that first exemption. Now, there's another enhanced Minnesota exemption I have not talked about, but it's important for all of you. You can get an additional $4 million estate tax exemption if you are actively farming your farm at the time of your death, even if you're just renting it, and you keep it in the family for 3 years after death. It's to help keep businesses and farms in the family. Then that Minnesota exemption goes from basically the $2 million to $5 million. And I've used that in 3 or 4 farm estates already, and in a couple of businesses. It only for businesses that generate less than $10 million a year in revenue. If you generate for other businesses, but for farms, it's unlimited. Any kind of farm family, it can be used for. This is what when I do an estate planning talk for somebody, I've got a definition of estate planning is just to do things that you can't take care of yourself and to transfer your assets at the time of your death as efficiently as possible. It's to appoint somebody to act for you when you can't do the job, and it's either a trustee or the term for executor in Minnesota is personal representative. And it's to determine who's going to get it, how they're going to get it, and when they're going to get it. And most of you probably don't have children under 18, but one of the things I say in all my workshops is that if you don't have a trust, every person gets their assets at age 18. And I like to use my family as an example. I'm the oldest in the family. When I was 18 and a half, I got a baby sister, and there were 6 of us. There were 4 in between. So if my mom and dad had died right after my sister was born with $600,000 estate and just a will saying everything to everybody equally, I would have gotten $100,000 to go to school with, and she would have gotten $100,000, and she would never have even made it through high school with it. So if you don't have a trust and you've got widely differing ages of children or grandchildren, you might not treat them equally, even though you intend to, because of their various stages of their life. And so most trusts say, I'm going to keep everything in my trust until my youngest child or grandchild is age 22. I want to give them 4 years of post-high school education if they want it, at the expense of everybody before I distribute anything out. Then we always say when the youngest is 22, we'll divide it up into equal shares as it then exists. So everybody educates those babies. Then I say one other thing. Today, and you all see this, between the ages of 18 and 30, our children and our grandchildren are away from home for the first time in their lives. They're growing up very slowly. They're with the worst group of people they're going to ever be with in their lives. They're very idealistic. They are going to be subject to all kinds of claims of con artists and hustlers, and they're going to make their money on one big deal, and they end up losing it on 1 or 2 big deals. So it's our job as parents and advisors to protect our children and our grandchildren from their own unwise spending habits and their vulnerabilities. So and I used to do this. I used to say half at 25 and a half at 30. I've gotten to be an old curmudgeon, so now it's a third at 25, a third at 30, and a third at 35. And some parents come in and say, oh, Lee, my daughter or son is 35 and they haven't even started growing up yet. So then we just move it on. And I've got a couple where we don't ever distribute it because they've married badly or they've got drug and alcohol addiction problems. So we give them income for life, just income. And then give them a certain amount of principal distributions at age 65 so they've got retirement. And the only reason I say all this is that you need a trust to do that, but a trust can easily do that, and then you need somebody to manage that trust that you trust that's going to do the job right. And I hope there's no corporate trustees in here because I do not like corporate trustees. They take all the money. And they have high fees. I'd much rather see 1 or 2 or 3 trusted individuals that are tight-fisted. Basically, that's the right. The older I get, the more important I think it is to be just plain tight-fisted because there are no really good investments that you can pick out there today that are going to be safe deals. You just want to protect the principal today. And there's a saying that I plagiarized from somebody else. I'm not so worried about a return on my principal as I am worried about a return of my principal. And as I pointed out, there's another slide, only with a trust can you divide up the assets so that you can maximize the deductions from both spouses. And so with a trust, you totally eliminate probate costs. In Minnesota, just the filing fee and the publication in the newspaper, which you eliminate with a trust completely, is about $750 per person. And the other thing is, only the nosy people that don't have anything to do are down at that courthouse looking at how much you have and who you're giving it to. And if you have it in a trust, all that's private. They can't get their hands on that. Nobody sees what you have or who you're giving it to. And so, as more and more of us have assets and we're in a declining health, once we put these assets in a living trust, we can name a son or a brother or a trusted advisor as a successor trustee that automatically takes over when you can't handle your assets anymore, and they're already in this basket. So we don't have to go to court and have a conservator appointed. We don't have to have a guardianship appointed. It's just a seamless transition, like a VP moving up to the presidency of a company. This, unfortunately, I don't have this slide in my booklet, but the only point of it is that with a will or without a will, you still have got to go through all the court processes. And if you have a living trust, which is on the right side, there's no court control, there's no probate. At death, assets can move immediately to the survivors. You can literally transfer assets at the funeral because you've got a trustee that's automatically in charge, and it takes just a few weeks to finish up an estate unless you've got assets that take a while to sell, or you have to file a federal estate tax return. So, that first point there, if any of you have assets in Iowa or South Dakota or Florida or Texas or California, winter homes, you have to have an ancillary probate in that state if you own those assets in your own name. If you own the assets in a trust, there's no probate. And so it's extremely important for multi-state property owners that you have your assets in a trust to avoid the probate. And even if you had them all in a trust in Minnesota but forgot and put your Florida home in your own name, you'd still have to have a probate here in Minnesota because that's where you live, and then an ancillary probate in Florida. So it just simplifies dying with assets. That's obvious. Covered most of these. And everybody says, well, Lee, isn't it a lot more expensive to set up a living trust than to do a testamentary will with a trust inside the will? And we don't charge anything extra. We charge exactly the same, whether it's a living trust or a testamentary trust. And I've taken the position, I'm on the minority, but we have the largest estate planning practice group in Minnesota of any law firm. But some of my partners in our Minneapolis office don't always agree with this, but I tell them, and they're coming around gradually, that it's going to be malpractice for a lawyer not to set up a living trust for large estates in the future, because it just takes too much time and it's too cumbersome to go through the probate process. And there's no safeguards in it. A secretary in the lawyer's office fills out all the petitions without any oversight. A secretary at the courthouse files it, and only if somebody complains does anybody look at it. And so there is no built-in safeguard that everybody thinks there is. The other thing, a probate, people don't think about this, but a probate process is simply designed to allow creditors to file claims. And many times it's where disgruntled children contest the will and just drive up the fees because they didn't get anything. And so in a trust, it's very difficult to contest, and they've got to start their own action, not just piggyback on the action you've already started.
Not gonna go into these.
One of the things that a lot of people have done in the past is set up joint accounts. Not only with a spouse, it's normal, but they do it with children. And I've had a lot of cases lately where a child has predeceased a parent, and then you have the worst of all situations where now the name on the joint account is deceased, and you have to probate that estate to clear the estate of the mother or the dad in order to get the assets properly transferred. So a joint account can be helpful in some ways, but in other ways they just cause unintended consequences. I did put that in there as a bone for corporate trustees. And this just, probate is anything that's in your own name. Non-probate, people ask this question, do I have to probate everything? And the answer is obviously no, and you know all those on the right side. If you are a joint owner, it goes to the joint owner at the time of death. Anything with a beneficiary designation automatically goes to the beneficiary. No ifs or ands about it. Life insurance, annuities, retirement benefits, bank accounts that have a POD on them. POD stands for pay on death, just a beneficiary designation. Mutual funds that have a TOD, that's transfer on death, or brokerage accounts, same thing. A lot of people don't know that, but you can put beneficiary designations on that. And 2 years ago, Minnesota passed another rule that most people are unaware of. You can now put a beneficiary designation on your land. Instead of giving a son or a daughter a remainder interest, you can do what's called a TODD in Minnesota. TODD stands for Transfer on Death Deed. And all you do, let's say I've got 4 kids, and I want to transfer a piece of land to my 4 kids when I die. I do a deed right now that says, I give my land to these following 4 kids. If I own it at my death, all they have to do is file a death certificate for me and an affidavit of survivorship. Bingo, it's theirs. And under that case, it does get a stepped up basis because I own it until I die. And if I want to sell it during my life, I don't need any of their signatures. I can just go ahead and sell it. It's exactly the same as a beneficiary designation on a bank account or a mutual fund or a brokerage account. So something you should all be aware of if your lawyers haven't told you. TODDs. That just, in Minnesota, a spouse cannot be disinherited. They're entitled to half of everything you have, plus more, unless it's a second marriage and they're not the mother of your children. Then they are cut back. And one of the things I would tell you, when I'm doing a family business transition plan for fathers and mothers with younger children that are either in their early marriage or about to get married, if they aren't married yet, I will require a prenup so that we don't run into a problem. And I say if they don't want to do it, just blame it on me. That we're not going to do any gifting to them unless they have a prenup in place. This is, one of my friends put this in here. You can avoid probate costs by creating a living trust. So I can use an inconvenient system created by lawyers to avoid a worse system created by lawyers. According to my watch, that witty observation cost you $4.